Welcome to another YouTube video in our continuing series on business acquisitions. My name is Christopher Neufeld of Neufeld Legal, and in this particular video we'll be discussing the importance of not downsizing or significantly reducing your purchase agreement, whether it's an asset purchase agreement or a share purchase agreement, when you are looking to acquire a business. Now, why is it so important that you work against reducing the size of a purchase agreement that you're putting forward? Well, to start off with, you're the one buying the business. So when you're buying the business and you're paying anywhere between $500,000, $1 million, $5 million, $10 million, you're the one who's doing the acquisition. You're putting up the money, and the other side that's selling should be prepared to agree to what your terms are, especially when the terms are largely, how should I put it, standardized or specific to the arrangement, but not asking for something too much. You're not asking for more money by way of this. You're asking for a degree of protections. The protections might be specific to the business, and that's where the drafting comes in, but there should not really be that much of a concern with respect to the level of specificity and the extent that you're asking for. Because what the seller is doing is they're offering up their business, and they're saying, here's my business. I'm assuring you, because I've been working at the business, I've been controlling the business for all these years, that the business that you're acquiring is as complete and thorough and above board as I'm saying it is. There's nothing hidden. There's no skeletons in the closet, nothing whatsoever. And that's what they should be assuring you and saying to you by way of the purchase agreement. And that's why you draft the purchase agreement as a purchaser and not the other way around. You're not coming in on a fire sale. You're putting up good, solid money to acquire a business that they know and they need to have cleaned up and clear to you. Now, what happens, and this is from experience, there are far too many purchasers who have overcommitted and said, well, you know what, the seller's saying this, and they tell me these stories, and they say, well, we have a good sense with the seller. And they're being upfront, they're being honest, there's nothing there. They don't like the length of the purchase agreement. They don't like the specifics that me as the lawyer is presenting. So what happens? Unfortunately, what's happened, whether it's when I am the key lawyer or also when I've been a junior lawyer back 10, 15 years ago on these transactions, what has happened is that these transactions have gone forward. And one of two scenarios happen. Either they've held firm to the depth and the length and the scope of the purchase agreement, and things have come up and they've been able to rely back on the purchase agreement, or alternatively, they've told ourselves as lawyers to cut back. They've reduced elements of it. They said, this agreement's too long. We don't need these schedules. We don't need this. We don't need that. Everything looks fine. We want to make it clean. We want to make it straightforward. And then what happens 6 months later, 12 months later? Stuff emerges. Stuff emerges out of nowhere. And what happens? They are hurt because of it. Because the seller was deceptive. The seller knew there was issues with it, but they wanted to cut it out. They didn't want to be as upfront and as straightforward as they should have been. And that is the problem. If you're being, and this is what I always say, if you're being upfront and your business is as clean as you say it is, and there's no problems associated with it, you should not have no problems with having a lengthy, highly detailed, highly specific to the business purchase agreement that protects the purchaser as much as possible. It should cover as many aspects. So as soon as you start seeing clauses being removed or suggested to be removed by the seller's lawyer or by the seller themselves, I seriously question that, and I push back on it. And even though I might push back on it, unfortunately, I do not have the ultimate say in it. It is the purchaser. You, the purchaser, who has the ultimate say. But be wary, be cautious. And I'm telling you from experience, when clauses are taken out, and then when specific clauses are created by lawyers such as myself who have experience in the realm to match what they believe is the business, and there's pushback on those clauses, be wary as to why that is the case. If there is not that problem, there should be no concern with it, because it's not going to hurt the seller. If the seller says the business is everything that it is, but if there's something hiding there, that is a point of concern. And it is up to you as a purchaser to ensure that you are protecting your business interests, because those are the only business interests that matter. And that is why when you work with legal counsel and you have them develop a purchase agreement for yourself that is matching what you are looking to buy, be firm with it, stick to it, and do not waver. And where you do waver, it's not waver, where you do modify, understand where the modifications are and make sure they are not going to come back and hurt yourself. It should not be a concern to the seller. The seller is walking away with a considerable amount of money, and they don't have to worry about the business afterwards. If there was a concern there and they're not enlightening you as to that concern, then you should not be acquiring that business possibly, or that should be calculated into the purchase price, representing a reduction, because you should not be buying a business and being saddled on top of that with hundreds of thousands of dollars of liability because they ask for some modifications, some shortening of the agreement, some cleaning it up. That is not what you should be doing. At least that is not my position from experience. I hope you have found this YouTube video of interest, informative, and a benefit to your own acquisitions. If you're looking for legal counsel that can help you in the acquisition process, buying any type of business, wherever it might be, that is what our legal practice does. So feel free to contact me. It's Christopher Neufeld, Neufeld Legal. Information contained in this web's YouTube and in the information related to the YouTube. And we look forward to seeing you again and helping you with your business endeavors. Thank you.